Good afternoon, one and all present over here. Marathwada Legal General Education Society's Manikchand Pahade Law College organized 1 week online lecture series on Code of Criminal Procedure, Juvenile Justice Care and Protection Act, and the Probation of Offender Act. Friends, this is the last lecture of this online lecture series. Today we have Soma Bhattacharya ma'am with us. She will guide us on the anticipatory bail in India. Soma Bhattacharya ma'am has completed her BA with distinction and MA in Indian History and Culture. She has completed her law graduation in first class and gold medalist. She has post-graduation in law with criminal law specialization with distinct and gold medal. She has qualified UGC NET in law. She was working as assistant professor of law at Gujarat National Law University, Gandhinagar, Gujarat. She has attended and participated in various conferences, seminars, and workshops. He has been a part of the national consultation on evolving a curriculum framework for law, poverty and development courses in law school organized by Center for Social Justice 2013. She was a member of the High Court Legal Service Committee. She has delivered a guest lecture at the Gujarat State Judicial Academy 2011. She was the consultation coordinator, Western Zone on consultation on project protection on children from sexual offences bill 2011. Organized at GNLU and participated in national level consultation organization NLU Delhi in association with NCPCR 2011. She has been the resource person on vertical interactions course for the prison officers in collaboration with IG Prison Gujarat and BPRD Ministry of Home Affairs, Government of India. She has conducted police training program sponsored by BPRD New Delhi in association with GNLU, coordinating the training program on human rights in prison management, organized in association with BPRD 2011. She was a judge for Stateston Laws Moot Court competition. Before I request to the madam, it is request to all the participants, if you have any questions regarding this particular topic, then you please put into the chat box. Now I request to ma'am, please kindly guide us on the topic of anticipatory bail in India. Over to you, ma'am.
Thank you. I hope the screen is visible to everyone.
Yes, ma'am. Yes.
Okay. Good afternoon, one and all present here, the respected faculty members, the student, and our very own dear CM Rao sir. Thank you for this invitation to have this discourse on anticipatory bail in India. So in this lecture, basically, first I would like to tell you the synopsis of the entire structure of this lecture. So first, I will start with what was the need, why it is introduced, this section 438, that is bail in anticipation of arrest, why it is introduced in India. And then I will discuss little bit of the provision, because provisions you can figure out, it's as simple as anything. But the main problem that we face when it comes to interpretation of these particular provisions. The entire interpretation process you will find sometimes it becomes a little bit complicated because of emotional aspect of the judiciary. I will show you how sometimes judiciary is overflown with emotion, that it forgets the main provision, what is there, and it takes a completely different course of action. And sometimes you will find that the entire provision gets entangled in the interpretation that is made by the lawyer. Even though the law is clear on a certain point, time and again, there will be a confusion rather than created confusion. And because of this created confusion, you will find that it is subject to interpretation. Maybe on the same question of law, it will be brought before the court of law. And again, it will be subjected to interpretation. Now, What I will do next is that I will show how this concept of anticipatory bail, how it has developed through different judgments, and what is the present position of anticipatory bail in India with the latest 2020 judgment with respect to interpretation of anticipatory bail. Now, why it is introduced in India? Basically, you will find the concept of anticipatory bail was not there in 1898 code. It was not there. It was introduced in the new code, and in the new code under 41st Law Commission report, this concept was introduced. And the main purpose, main objective of introducing this anticipatory bail was what? It was just to protect the accused from the harshness of arrest, from the harshness of any kind of pre-trial detention, any kind of lockup torture. That was the main purpose, to provide that protection. This concept was introduced. Now, when this concept was introduced, you will find, if you read the provision, there are many aspects, many words in the provision, which on the face of it, it seems very simple. But when it comes to the real factual situation, the same wordings becomes very, very complicated. For example, if you read section 438, what does the section say? When a person has reason to believe. Now, what is that reason to believe? I will interpret it later on, but please mark it here. When a person has reason to believe. What is that reason to believe? That in near future, he is going to be arrested. And arrested for what kind of offenses? Non-bailable offenses. Please mark it, non-bailable offenses. So what he can do in such event? He can approach either High Court or Court of Session. And for what purpose? That in the event of his arrest, direction to be issued by the High Court or Court of Session, that in the event of his arrest, he should be released on bail. And what are the considerations that the High Court or Court of Session has to take? Before granting or rejecting his application, High Court or Court of Session shall take into consideration the nature and gravity of offense, of course, the antecedents of the offender that is required, possibility of the offender to flee the course of justice, and finally, whether this particular allegation is made malafidely in order to tarnish the reputation of the accused. Now, with this respect, I will just like to comment little bit on 203 Law Commission India report, where when the consultation proceedings were going on the Law Commission report, Madras Bar Association, they have suggested that suppose if the anticipatory bail application is made in the Court of Session and the Court of Session rejects it, then at least one right to appeal should be allowed to High Court until the time it is not disposed of by the High Court. What is to be done? The person shall not be arrested. It was just a suggestion that was made. Another interesting suggestion that was made in the consultation proceedings of this Law Commission report was that if the application is made either to Sessions Court or High Court, then in that case, the second anticipatory bail application shall not be allowed. That means, if you remember, it will remind you of 397 of CRPC, that is revision. That if one revision application, if it is made, second one is not allowed. In the same way, this suggestion was made that if one application, anticipatory application, bail application, if it is made before Court of Session or High Court, the second application shall not be allowed. That was the interesting suggestions that were made. Now, those suggestions, keeping it aside, although it was not accepted, later on that report was not completely accepted. Proceeding further, you will find that after considering the grounds that were given here, the nature and gravity and the antecedents and possibility of fleeing, and the lastly that whether it is done by malafidely or not, if the court rejects the application or if it is under consideration, it is open for the police officer to arrest that particular applicant. But if the interim bail is granted, then in that case, not less than 7 days notice shall be given to Superintendent of Police and the public prosecutor, and a hearing shall be given to the public prosecutor. And in the hearing, the presence of the applicant is obligatory. If the public prosecutor makes an application to this regard, and the court also thinks that it is necessary. After giving final hearing, after giving hearing to this public prosecutor, if the court is of the opinion that the bail can be granted, if it is rejected, nothing can be done. But if the court thinks that the bail can be granted in this particular case, then in that case, subject to the condition, the bail will be awarded. And we know the statutory condition that he shall not flee the justice, he shall not leave India, he will not induce. Induce to whom? Induce the witnesses, the victim, not tamper with the evidences, and any other such condition which the court deems fit. Now, after getting this application, after granting this particular bail, if the person is arrested by the police officer, and in the event of that arrest, if he is ready to furnish the bail, bail should be taken from him and he shall be released. And if the magistrate is issuing any warrant, then the nature of the warrant shall be bailable in nature. But nothing in this section shall apply in the cases of 376 group of offenses. This is, in short, is your provision that is talking about what is an anticipatory bail and the procedure to grant it. But the complication with respect to this anticipatory bail application, it was encountered in the case of Gurubakh Singh Sibba and others versus State of Punjab. Now, from here, we are conceptually developing this proposition of anticipatory bail. And you will see that the question of law, time and again, how it is changing with different cases. Now, here in this case, what happened? This Gurubaksh Singh Sibba, who was a Minister of Irrigation and Power, the charges of corruption was levied against him. And he approached Punjab and Haryana High Court in order to obtain a direction from the court that in the event of his arrest, he shall be released on bail. Now, what Punjab and Haryana High Court did was that not only it dismissed the bail application, but it has given 8 guidelines in order to control the operation of anticipatory bail. If you remember, before starting the lecture, I told you that sometimes courts are flowed with emotion. And in that emotion, that is bound to happen. In that emotion, what happened? They include certain things which are not required as per the statute. So the guidelines that were issued by the court was, you can just go through it. I've just put it as a pointer, that anticipatory bail, the power of anticipatory bail, it is of extraordinary character, and it shall be used sparingly in exceptional circumstances. The blanket cover, the second guideline given by Punjab and Haryana High Court was that the blanket cover of anticipatory bail is not available. The power under 438 is not unguided or uncanalized power. In order to obtain anticipatory bail, the applicant has to make a special case. Not only this, the cases where there is a possibility of obtaining incriminating material, in those cases, anticipatory bail shall not be granted. It shall not be granted in the cases of death or imprisonment for life or economic offenses. And the court, lastly, shall ensure that the allegation of malafidness is substantial in the cases of anticipatory bail. Now his application was dismissed. Now what will happen to him? He approached Supreme Court through special leave to appeal. And the question of law was clear. And that is where court stated here, court has actually gone into 41st Law Commission report to answer the contention, the question of law, that whether anticipatory bail can be granted in this instant case or not. And while analyzing 41st Law Commission report, very pertinent point was observed by Supreme Court. And that is where, highlighting the purpose and object, Supreme Court stated that anticipatory bail was not there in the old code. It is introduced in the new code. And what was the purpose of introduction? To protect the accused from unnecessary harassment of arrest. Another interesting thing that was observed by Supreme Court, where court has categorically stated that there is a distinction between 437 and 438. 437 means the person is produced before other courts. But 438, what does it say? It is before High Court or Court of Session. Why? Why it is High Court or Court of Session? And that is where court marked that the Law Commission report is very clear, where it stated that High Court or Court of Session is manned by experienced judges. That is why legislature have vested this power on High Court or Court of Session in terms of application of anticipatory bail with respect to 438. That is why if you find, I told you, High Court or Court of Session may, that means what? The complete discretion is given to High Court or Court of Session with the faith, with this belief, with this confidence that these two courts are manned by the court of experienced judges. And on case-to-case basis, they will decide whether to grant anticipatory bail or not. Further, court stated that often we are making one mistake. Somewhere we mixed up the provision of 437, 438 and 439. 437 is applied post-arrest and 438 is applied pre-arrest. If the legislature wanted, they could have read those conditions that is imposed by Punjab and Haryana High Court. If the legislature wanted, they could have read those restrictions in 438. But it was left completely to the judges. Let the judges decide. And when legislature is not putting any restriction on the operation of 438, then why High Court is so inclined to restrict the power of 438? Leave it to High Court and Court of Session and let them decide. Stating this thing, High Court, whatever guideline that was given by Punjab and Haryana High Court, that was examined thoroughly by Supreme Court, stating that the powers under 438, yes, we agree with the first 3 points, that it is an extraordinary power. The blanket order of anticipatory bail is not available. The power is not unguided or uncanalized. We agree. That is the reason why this power is conferred upon High Court or Court of Session. But next thing, when it is saying that a special case has to be made out, and that is where Supreme Court stated that whether 438 anywhere is talking about special case, no. It is only stating non-bailable offense. That's it. When it is stating non-bailable offense, then in that case, from where High Court is bringing this special case concept, case is a case. There is no special or less special kind of concept. It is a case and you have to ensure it's a non-bailable offense. That's it. Further, and this is the most important point which is debated even today in 2020, that is where Supreme Court stated that when anticipatory bail is granted, grant it. Don't mention any duration, grant it. If that particular person, the applicant who subsequently becomes an accused, if he is required for any kind of interrogation, then in that case, the public prosecutor can approach the court for the cancellation of the bail. But if the person is cooperating, then in that case, let it operate. What is the harm? After that, with these two concepts, that anticipatory bail is not available as made by Punjab and Haryana High Court, in the cases of death or imprisonment for life or economic offenses, that is where Supreme Court questioned the High Court that these kind of guideline is going against the basic concept of presumption of innocence. And that is where court stated that don't read 437 in 438. In the 437 subsection 1, they are mentioning that bail shall not be granted. First, it shall be granted in the cases of non-bailable offenses, but it shall not be granted if the offense is punishable with death or life imprisonment. That is there under 437. Don't read that restriction in 438, because if the legislature wanted that those restrictions which are there in 437, it should apply to 438, it could have easily mentioned it, that the restriction mentioned in 437 applies on 438. When it has not mentioned this thing, that means what? That means leave it to the judges. Further, court stated that you only have to show that there is a malifiedness in the acquisition. There is no question of substantiating the malifiedness. If you go for substantiating the malifiedness, then better you enter into trial procedure. Only thing you have to establish is that there is a malified in the acquisition. That's it. Clarifying after examining all these guidelines that were given by Punjab and Haryana High Court, Supreme Court stated, do you remember I told you, mark it, reason to believe. Supreme Court stated that there are some points that is required to be noted by all the high courts and trial courts, that is your court of session. They have to note before granting this anticipatory bail. First point, when it comes to reason to believe, it's a very simple word. But what is that reason? It must be based upon some concrete fact. Mere apprehension or fear doesn't amount to reason to believe. Second point that was pointed by Supreme Court was that the applicant only had to make out a case. No need to make out a special case. That is not required. Third, filing of FIR is not the condition precedent for the grant of anticipatory bail. It can be granted before FIR, after FIR, but once the arrest is done, 438 has no application here. With this, the court granted the anticipatory bail in that particular case. Any question, any doubt?
There is no question in chat box, ma'am. Go ahead.
Okay. Now, next you will find that was the stand. In which year it was taken? It's a decision by Constitutional Bench of Supreme Court, Guru Bakht Singh Sibba. Okay, here you can note 1980. Now, afterwards, what happened? Please remember, Guru Bakht Singh Sibba is a decision of a constitutional bench. In these cases are basically the cases which I have highlighted in red. These cases are basically delivered by 1 or 2 judges bench. First is 1, and the rest of them you will find the decision by 2 judges bench of Supreme Court. After Guru Baksh Singh Sibba, there were remarkable change in the concept. Remarkable change means in Salahuddin Abdul Samad Sheikh versus the state of Maharashtra and K.L. Verma versus state and another. In this case, what happened? Anticipatory bail was granted for a limited period. And Supreme Court advocated saying that anticipatory bail is always for a limited period. On the expiry of the limited period, applicant has to submit before the court of magistrate and get the regular bail under 437. And justifying this particular concept, Supreme Court stated that anticipatory bail is granted when the investigation is pending, and the grant of anticipatory bail nowhere undermines or bypasses the power of lower court. That means anticipatory bail is bound to be for fixed period. On the expiry of the said fixed period, it is expected from the accused that he will submit before the magistrate and obtain the regular bail. That was observed in Salahuddin and K.L. Verma. Further, I told you, sometimes court are overflowed with emotion. In Nirmaljeet Kaur versus Sunita Devi, they also maintained the same proposition that anticipatory bail is for limited period. But one interesting rectification they made here is that fine, it is for a limited period, we agree. Now, after limited period is over, how he can straight away go and file for regular bail? Because for filing for regular bail under 437 or 439, the person needs to be in custody. That means once the fixed period of bail is over, that anticipatory bail is over, the applicant has to be arrested, and in custody only he can go for 437 and 439. Good, that was done. But in Sidram Satling Mahatre versus state of Maharashtra, again Guru Baksh Singh Sibba was revisited. And that is where Ram Jethmalani stated, if you remember the guidelines here pertaining to incriminating evidences, Ram Jethmalani has particularly taken up that paragraph and stated that this court, that means in between all these judgments which was rendered, they were unable to appreciate that particular guideline. Because in that guideline, it is stated by the court very clearly that let them continue with that anticipatory bail. If the accused is required for the purpose of interrogation, obviously application can be made, and what can be done? Their custody can be asked. So that is where in this judgment, Supreme Court realized, you may say in 1980 that Guru Baksh Singh Sibba was delivered. In 2010, Supreme Court realized that the stand that they have taken in Guru Baksh Singh Sibba, that was a correct stand, And in between all these judgments, which are the fill up the blanks judgment, these judgments were declared as per incuriam. But unfortunately, in Siddharam Mahatri, if you see, it is again, you will find the facts were somewhere not so, similar. But the thing was that there was a political rivalry between two parties and murder happened. And this Siddharam Mahatri, he happens to be the applicant, the accused in this particular case. Now, that is where you will find after 1918, 2010, they realized that the stand taken by Supreme Court in 1980 was correct. And in between these judgments, these are per incuriam. But Siddharam Mahatri was decided by a bench of 2 judges. Again, this question of anticipatory bail, it surfaced in this case of 2015 case of Bhadresh Bipinbhai Seth versus State of Gujarat. Any question, sir?
Yes, ma'am. There is one question. Whether the second application for anticipatory bail before session court is maintainable. If yes, whether there are any conditions. Questions come to the mind of this particular person because he go through the case Jagmohan Bahal versus NCT Delhi 2014.
Sir, there is one thing that is for sure. Second application is maintainable only when the person is not arrested.
Okay, ma'am.
If he is arrested, then he has to go under 437 or 439.
Yes, yes.
Okay, because even Guru Bakht Singh Sibba last guideline is saying it is operable till the time the person is not arrested.
Yes, ma'am. There is no question.
Okay. Now, in Bhadresh Bipinbhai Seth versus State of Gujarat, in this particular case, what happened? This is a very complicated facts. Complicated in the sense that complainant has taken, we can say at least that she has tried to take the system for a ride. In 2001, 29th May, she makes an application. Application means in the form of a complaint. She writes a complaint to the Assistant Commissioner of Police, stating that appellant in this instant case, Bhadresh Bipinbhai, he has subjected her to molestation, to threat, blackmailing. And after recording her statement on 31st May, police lodged FIR under section 506, subsection 2 of IPC. Now, what that lady did, please remember the timeline. FIR was lodged on 31st May 2001. In 2010, she filed an application before Metropolitan Magistrate requesting the Metropolitan Magistrate to add charges under section 376. And the Metropolitan Magistrate stated that it will be done only after examination in chief is over. She was not happy with the decision. She approached Court of Session. And Court of Session directed that there must be a fresh hearing with respect to this addition of charges. Revised charge sheet was filed. In the revised charge sheet, 376 was added as a charge. And when 376 is added as a charge, what magistrate can do? He cannot try it. He committed the matter for trial under section 209 to Court of Session. Now, what this accused did was that he filed for anticipatory bail before Court of Session. And the Court of Session granted that particular bail. Complainant who was there, she contested it before High Court. And what High Court did was that High Court rejected the bail application, that anticipatory bail, that granting of that bail by Sessions Court. And that was basically what? That was rejected. That was basically set aside. The granting of the bail by Court of Session was set aside by the High Court. So what appellant did was that through special leave to appeal, he approached Supreme Court. And before Supreme Court, the contention that he raised was that this application, that means this anticipatory bail application that was there, whether he should be eligible to be released on anticipatory bail, released in the sense whether he can avail that particular anticipatory bail, and whether High Court was justified in doing what? In setting aside that grant of anticipatory bail. Now, answering these two questions were clubbed together, and the Supreme Court answered that first incident that happened in 2001, at the time of framing of the charge, this 376 did not appear anywhere. After 2001, there is nothing on record to show that these accused, that is the applicant, he has tried to give some threat to the victim, or he has violated any of the condition, or he has tried to or escaped the process of, any kind of process of, you can say, any kind of court proceedings he has tried to escape. So, in such circumstances, it was unjustified on the part of the High Court to set aside this grant bail, anticipatory bail, and the original decision of Sessions Court, where Sessions Court allowed his anticipatory bail, that was restored. And while restoring it, court has given the direction to whom? To all the trial court and High Court, that before granting anticipatory bail, what are the facts, what are the things that is to be taken into consideration? And that is where the 3 judges bench, they have given these guidelines. And the first guideline in this is that the application of anticipatory bail should be thoroughly examined. Now, what is that thorough examination? First thing, court has to see that whether there is any kind of dispute between the complainant and the applicant. Whether complainant is in a habit of filing complaint, and that too a false complaint. If that is the case, complainant shall be seriously dealt with. If the complainant is acting in connivance with the investigating officer, then the action shall be taken against the investigating officer also. That is where Supreme Court clarified what amounts to thoroughly examined. The investigating officer, second point, when he is conducting an investigation, he shall thoroughly see the exact role that is played by the accused. And when the investigating officer decides to arrest the accused, in exceptional cases, investigating officer has to give reason. He has to record the reason, which will help the court to formulate an opinion. Next, the court, while considering anticipatory bail application, shall meticulously go through the facts of the case. What is the reason? Because court has to ensure that if it is rejecting this anticipatory bail application, there will be a far-reaching consequences that will flow. That means once the accused is arrested, you know the society will never go into the question whether this person was subsequently acquitted or not. The factum of his arrest will be imprinted in the mind of the community, of the society. And it is not only traumatizing for the accused, but it is also traumatizing for the family. So any case of, rejecting, before straight away rejecting that bail application, anticipatory bail application, a meticulous precision in the evaluation of the facts has to be done. No justification in reading 437 into 438. If you remember, it has to be a special case. It has to be a case only. There is no question of special case or substantiated malafidness. All those things are not required. The proper course of action has to be taken while considering the anticipatory bail. What is the proper course of action? What is the proper course? Nature and gravity of offense. All this meticulous, antecedent of the offender. Right? Now in nature and gravity only, court has to see all this meticulous precision and everything. Antecedent of the offender, possibility to flee his justice, whether this allegation is made in order to tarnish his reputation. After considering this thing, interim bail should be granted. And after granting the interim bail, hearing will be given to public prosecutor, and only after that, the court will decide whether to finalize the bail or not. If the court decides to finalize and grant him the bail, there will be a conditions that will be there. And those conditions, obviously the accused, the applicant who is there, he has to follow those conditions. And in case there is any breach, then the investigating officer or public prosecutor may approach the court under 439 subsection 2 for the cancellation of anticipatory bail. Not only this, the applicant can also approach the court. Obviously, he will not approach for cancellation, but what he can approach for modification in any terms and condition in the bail. Now comes the seventh point. That is where court stated that once the anticipatory bail is granted, let it continue till the end of the trial. There is no point in telling him that 438 is granted for a fixed period. On the expiry of the fixed period, submit to the custody and go for regular bail. All these hardships are not required. As long as he cooperates, behaves properly, cooperates in the proceedings, cooperates in the investigation, let this particular thing, that relief that is there, let it go till the end of the trial. But it is also necessary, that is where the next thing comes, that 438 shall be exercised with caution and prudence by considering all the relevant circumstances. And that is where the last point adds to point number 8, that there is no straitjacket formula that can be adopted for the grant or refusal of bail. There cannot be any straitjacket formula. And the cases has to be determined based upon the individual facts and circumstances. And interestingly, in Cr.P.C Sibba also, Supreme Court has stated that each and every case is unique in its own facts and circumstances. That is why the power is given to High Court or Court of Session, so that it can decide it based upon case-to-case basis. Further, court has stated, and these are the points from day one you will find in bail or in bail in non-bailable offences, anticipatory bail. This is a common, even in statute also you will find the same thing, that before granting anticipatory bail, what are the things, what are the parameters that is to be considered? You will find nature and gravity, antecedents of the applicant, possibility of the applicant to flee from the justice, possibility of the offenses, okay, whether there is some kind of element of humiliation is there in the allegation, the effect of granting anticipatory bail on the large people, magnitude of people on community, okay. Not only this, one essential thing that is to be very pertinent added thing is there, while granting anticipatory bail, the rights of the investigating officer shall be balanced with the freedom, liberty, protection that we grant to the accused. This balancing factor has to be there. That means very carefully court has to examine the facts and circumstances. Next, you will find after you release the person, whether there is any threat from him to the larger society, whether there is a case of frivolous prosecution. All these aspects are required to be considered here. Further, the same, understand this is a 3 judges bench. Now, again, the matter surfaces in the case of Shushila Agarwal versus State. And in this case, Cr.P.C Sibba, Sidram Mahatre, Bhadresh Bipin Bhai was on one side, and on the other side was your Abdul Samad, K.L. Verma, Nirmaljit Kaur, Sunita Devi. These 2 groups of judgment were on both the sides. And now the court has to settle the question of law. Any questions so far?
No, ma'am, there is no question.
Why people are
Yes, ma'am, there is a one question.
Hmm.
If suppose the custodial interrogation is needed from the accused regarding the offense alleged to have been committed, then
If the
custodial interrogation is needed from the accused regarding the offense alleged to have been committed, then
in that case, it is already clear in Cr.P.C Sibba that make an application to the court which has granted the bail, okay, make an application that you require the person for custodial interrogation. So in that event, what court will do? Court will end his bail anticipatory bail and direct him to submit to custody. It is always subject to this condition.
Yes, ma'am.
Okay, it is always subject. I think Guru Baksh Singh Sibba is also saying the same thing. That if you require him, make an application, request the court, and then court will see to it subject to the your condition and all these things. Court must direct for the purpose of interrogation. But then after that, there will be no anticipatory bail. Then he has to go under regular bail. Okay?
Yes, ma'am.
Okay. Now, in Shushila Agarwal versus State of Delhi, this is the last case in this segment. Here, in this particular case, I told you two groups of cases were in conflict with each other. Right? Now, the very pertinent two questions of law that was there before Supreme Court was that whether anticipatory bail can be granted for indefinite period or unlimited period, whether anticipatory bail can be granted for unlimited period, and second, when the court summons any accused who is out on anticipatory bail, whether that anticipatory bail expires with the summoning of the court, whether the anticipatory bail expires on the summoning of the court. Now, whosoever has asked this question, just now what sir was telling, this question of law is answered in that favor. It is stated that no doubt anticipatory bail is for unlimited period, but it is subject to the control, it is subject to the condition, the pros and cons, whatever the court deems fit, it is subject to that. Are you getting it, sir?
Yes,
Sir,
ma'am.
I hope the person who has asked the question, this answer will satisfy him.
Yeah, definitely, ma'am. Definitely.
Okay, that whatever you do, if this is the condition you want to impose as a court, you can go ahead, impose it. It is subject to the condition, pros, cons, whatever you want to do as a court, you can do it. You have every right, but it is for unlimited period. And second, the question that whether the summoning of the court expires the anticipatory bail, answering that question, Supreme Court stated that no, it doesn't expire. Further, court pointed out that before granting anticipatory bail, some points are required to be noted by the High Court and Court of Session. And these are the points, and you will find these are the points are in consonance with Guru Baksh Singh Sibba, Siddharam Mahatre, and what was the last case? Bhadresh Bipin Bhai. That anticipatory bail shall be granted on concrete facts. Concrete facts in the sense, the nature and gravity of the offense and all those aspects has to be taken into consideration. Now, in the second guideline, that is where I said court get little bit emotional. What court is saying, if you remember the provision, what does provision says? Court can grant the interim bail. After granting interim bail, hearing will be given to public prosecutor. I suppose, if you remember, this is what the provision says. Now, in this second guideline, where I have noted it as a pointer, if you read the complete guideline, you will find court is saying that notice is to be given to the public prosecutor, but not only for the final hearing of the anticipatory bail, but also at the stage of granting interim relief. I suppose you can make a distinction. Provision is saying once the interim relief is granted for final hearing, you can call the public prosecutor. But here in this guideline, what is Supreme Court saying? That no, not only final hearing, even for interim hearing also, interim relief also, public prosecutor should be given hearing. Please note it. I have nothing to comment here. Okay. Now, next is, as a court, you can impose the condition. You can state that if you are required for interrogation, you have to submit to the custody. You have to require for whatever condition you want to impose, you can impose it here. Okay. Next, nature and gravity of the offense is the most important determining factor. Not only this, if you see the conduct and behavior of the accused till the end of trial is the fact that is to be considered. If the conduct and behavior is not proper, public prosecutor may file an application for cancellation of bail under 439 subsection 2 before the court, which has granted it, that the conditions are violated. So what that court can do, it can cancel that anticipatory bail. The blanket, it is not a blanket order. If you remember the same wordings used in Cr.P.C. It's not a blanket order. It's not an order that will operate on future offenses. And neither it restricts the rights and duties of the police, right? Nor it is to be taken as a blanket order. That means anticipatory bail, if it is granted, now the applicant has to be very cautious. He has to cooperate with the police officer in terms of investigation. So granting of anticipatory bail does not limit the rights of a police officer to conduct an investigation. The public prosecutor or investigating officer, they can claim the benefit under Section 27 of Indian Evidence Act. And for this purpose, they can make an application, as I already told you, under Section 439 subsection 2 for the cancellation of bail. Now, if the anticipatory bail is granted by one court, the justfulness of the same can be questioned before appellate court or superior court. And the superior court or appellate court, what it can do is that it can set aside the decision of this granting of anticipatory bail, and the setting aside does not amount to cancellation of bail. So you will find in this entire discourse, time and again you will find there were some repetition of concept, some clarification. What was clarified way back in Cr.P.C, time and again it is subjected to challenge. And to my mind, this is happening as the court has correctly observed in Bhadresh Bipin Bhai, that since there is no straitjacket formula, that bail has to be granted if this condition satisfied, and where the Supreme Court itself is saying that the cases are unique. Each and every case is unique. Each and every facts are unique. When the Supreme Court itself is stating this thing, that means what? This complication is not going to rest here. Time and again, we may have to encounter this position that whether anticipatory bail should be granted or not, or what is the condition, or whether the condition is valid or not. Any question, sir?
No, ma'am, there is no question.
So I end my presentation.
Hello.
Hello.
Yes. Dear participant, this is the last lecture of our 1 week online lecture series on Code of Criminal Procedure. I request if you want to make some feedback on this particular online lecture series, then you can unmute yourself and put your feedback on this particular open platform. Now I request Ravi Kiran Shukre, please give us some feedback on this particular lecture series.
Hello.
Yes. Yes, Ravi.
Sir, am I reaching to you?
Yes, go ahead.
So first of all, very thank you, ma'am. The lecture clarifies every doubt regarding the anticipatory bail. The case laws provided by you were extremely important. Very grateful for that, and thumbs up. And once again, thank you for your delightful lecture.
I'm happy that you enjoyed it.
Now I request to Gayatri. I think Gayatri is not there. Okay. Now I request to Dr. C.M. Rao sir, a principal of MP Law College, to give some concluding remarks on this online lecture series on the Code of Criminal Procedure, Juvenile Justice Care and Protection and Probation of Offenders Act. Over to you, sir.
1 minute. Madam, on behalf of the management staff, I thank you for your wonderful academic feast, which we enjoyed on the last lecture. When you asked last, I don't understand why you asked last. It is short and sweet and a wonderful experience for me also, because I taught this subject 12 years back. Almost all in 2008, I taught this subject. So the way in which you expressed this particular topic is wonderful. And I hope all the particular participants, because this is the particular final year students who are going every day for court for internships. And these particular lectures are going to be uploaded in YouTube. And as a result of which they are going to have the glance of this subject, and around 300 to 400 people every day observing each lecture. That is the benefit of this lecture series. Once again, I thank all the participants who have participated in this particular program. And once again, I thank you, madam, for your wonderful, delightful, and short and sweet academic feast which was happened at this particular juncture. Thank you, one and all, for your wonderful.
Sir, you gave me only 1 hour, sir.
No, not at all problem. 1 hour, because these people doesn't have that much of patience. Only we are doing every day 2 lectures.
Yeah, I could figure out.
Because ours is a rural background, and the people doesn't have the habit of going for technology and all those problems. Only 2 hours. Evening special lecture series. From Monday onwards, jurisprudence. Next Monday, constitution, like that. We are going every week, one week lecture series.
Okay.
Thank you. We'll join you again for another academic feast. Thank you, madam.
Okay, sir. Thank you.
Thank you.
Dear participant, there is a small announcement. From 20th December to 2nd January, we have an online lecture series on the jurisprudence. The detail of the program is already circulated on the WhatsApp and other social media platform. So thank you very much, ma'am. On behalf of management, staff, and student, I am very thankful to ma'am who give a wonderful lecture on the anticipatory bail in India. I also thankful to all the teaching and non-teaching staff. I also thankful Dr. C.M. Rao sir who gave a concluding remark on this particular online lecture series. I am thankful to all the participants who join and enjoy this particular intellectual feast. With this, thank you one and all. Thank you very much.
Thank you, sir.